Hello everyone, this is Ed Park from ATMS Logistics. Today we are going to talk about one of the most stressful documents that U.S. Customs can issue to an importer, CBP Form 5955A, the Penalty and Liquidated Damage Notice. I will continue to upload more in-depth content covering various topics related to U.S. importing. Please support the channel by subscribing, and turn on notification. Let's dive into today's topic. Even though we hope none of our subscribers ever have to deal with this, there may be an unavoidable situation where you may receive CBP Form 5955A, the Penalty and Liquidated Damage Notice. This document is issued when U.S. Customs determine that a customs law violation or breach of bond conditions has occurred. This is not simply a notification. It is a legal demand letter that requires payments for penalties or liquidated damages. To prevent this from happening, it is critical to ensure accuracy in all customs documents and to maintain proper record keeping for at least 5 years from the date of entry. I've included a link here to the video we create on the 5-year record keeping requirement. And of course, if you have received a penalty or liquidated damage notice, it is extremely important to respond promptly. We will cover this part in more detail later in the video. Two main types of claim under CBP Form 5955A. The first type is a penalty assessment. This is based on 19 U.S.C. 1592. The purpose is to penalize and deter violations such as false statement, undervaluation, or improper importation of prohibited goods. Some common reasons customs issue this notice include false or inaccurate information on the entry document, incorrect customs valuation, or fraudulent commercial invoices. Lastly, importation of prohibited or restricted item. Second type is a claim for liquidated damage. This is based on 19 CFR Part 113, which governs customs bond. The purpose is to recover losses caused by a violation of bond condition. I've included a link to our video explaining the U.S. Customs bond system. Common reasons for liquidated damage include failure to comply with a customs redelivery order, failure to file required entry document within the prescribed time frame. Lastly, violation of TIP, which is temporary importation bond requirement. Now, let's take a look at the key component of a penalty and liquidated damage notice. First is the case identification section, including the case number, issue date, port of entry, and relevant entry numbers. Essential information that tells you when and where the issue is originated. Second is information about who is responsible for, whether the importer, the surety company, or another related party. Next, the notice states whether the claim is for penalty or liquidated damage. It also includes the specific reasons why notice was issued. The notice provides instruction on how to request mitigation or cancellation along with applicable deadline. Importantly, the claim amount assessed by Customs is clearly stated. In the near future, we'll cover the petition for release process in more detail, but here is a brief overview. A petition of relief must be filed within 60 days from the date the notice was issued, not the date of you receive. The issue date is printed directly on the Form 5955A. The petition is governed by 19 CFR 171.2. If you fail to respond within the deadline, Customs may pursue the claim directly with the surety or collect the amount themselves. If Customs collects from the surety will later demand repayment from the importer. The failure to repay can result in the bond being terminated, meaning you may no longer be able to import. Let's take a look at how you should respond if you receive a penalty or liquidated damage notice. First, take action immediately. Typically, you have 6 days from the issue date to respond or file a petition. Ignoring can result in a full amount being enforced or the case being referred to Department of Justice. Second, carefully review the alleged violation, the legal base, dates, fact, bond information, and all related details. Compare Customs claim against your own documents and records. Determine whether the claim is for penalty or liquidated damage. The penalties related to document error or false statement. Liquidated damage related to violation of bond condition. Confirm whether a real violation occurred or it is simply issue of errors, clerical, or based on incorrect information. Gather supporting document. If you have maintained proper record, you should already have the necessary documents on hand. If you believe cancellation or mitigation is possible due to minor violation or unavoidable circumstances, prepare and submit a petition for relief. Explain the fact and circumstances. Provide all supporting evidence. Present corrective actions and prevent measures. Request mitigation or cancellation clearly. If Customs deny the petition, you may file a supplemental petition. If the claim amount is significant or issue is complex, seek help from a customs broker or attorney specializing in customs law. Today, we reviewed one of the most stressful documents an importer can receive, CBP Form 5955A, the Penalty and Liquidated Damage Notice. I will continue to upload more in-depth videos on various import-related topics. Please remember to like, subscribe, and turn on notification. If you have any questions or need assistance, feel free to contact me at the email shown on the screen. I'll be happy to help. Thank you very much for watching, and I'll look forward to seeing you again in the next video. Have a wonderful day.